Welcome back to my coverage of the Kristin Smart Trial. As we head into another week of the trial, I wanted to share some more interesting tidbits that I've discovered during my research. Chris Lambert from Your Own Backyard podcast, who even Sheriff Parkinson credited for renewing the case and rattling cages and finding witnesses and etc. We're going to hear from him in a moment, but I just have to wonder what the heck was going on with law enforcement back then when they dropped the ball. And it's more like not what was being done because nothing was being done. And it's really hard not to bash on the Cal Poly Police Department, the SLO Police Department, the San Luis Obispo Sheriff's Department, because they really did mishandle this case. But we're going to focus on the positive, and we're going to be so grateful that Chris Lambert and all his efforts look like they're paying off, and we might actually finally get justice for Kristin.
What am I missing? Why weren't we doing this 20 years ago?
Yeah, that is a great question. And I think they could have done it 20 years ago. I mean, I think they had enough. They had the cadaver dogs that smelled something in his bedroom. They had witnesses that she was all of a sudden more passed out than she should have been with the amount they saw her drinking. And we've seen cases where there's circumstantial evidence like that brought to trial. I think there's a big difference maybe now, the Me Too movement and maybe the willingness of women to come out and talk about situations that happen to them. Perhaps we are more willing to think that somebody could have been raped and murdered, even if she was just leaving a party. So perhaps culture has changed a little bit. And of course, the podcast. But I agree, they have more evidence. It sounds like it's sealed, but they have them on tape saying something. We know that. That obviously led them to bring the charges as well as what they found under the deck. So they got more concrete evidence. But I do think there was enough to have brought the charges back then. And the timing, the memories of the witnesses, that's going to hurt them with how long they took.
Yeah, it's going to be a much more difficult case. Assuming that there isn't this big gotcha, piece of evidence that they have now, which led to the arrest, which we will find out possibly Thursday when they unseal the record, but for sure during the trial itself.
I'm sure most of us never even think about the extended Flores family, but I do recall the cousin's information regarding him being a pervert. I have that in my Wasna video if you want to hear the details. Chris Lambert has been in contact with the rest of the family, and I'm not surprised what he has to say.
Members of their extended family, though, and it was interesting to me how many of them were willing to talk to me but didn't want them to know they were talking to me, which to me says, we kind of know what's going on here, but we don't want them to know.
In my opinion, the defense has been pretty weak so far, and the victim bashing thing, most say, is really gonna bite him in the butt in the long run, as far as public opinion and even expert opinion. And the simple, she went that way and I went that way, is that really going to fly? Here's a little bit more about what Chris Lambert had to say as he sits in the courtroom and is able to see all this firsthand.
I hear a lot of the Smart family that displeased with kind of putting Kristin on trial too.
Yeah, I think the defense's case is the same that the Flores defense has been all along, which is he went that way, she went that way, and just sticking with that. We don't know where she is. Where's the body? Where's the body? He went that way, she went that way. But the defense doesn't seem to hold a lot of weight under examination. The more that you have all these people testifying as to the type of behavior that they saw exhibited, Paul's interest in Kristin the night that she disappeared, Paul being the last one seen with her, as well as when you get into the injuries he had later that weekend, the fact that he lied and then he admitted that he lied about those, it all starts to add up.
The law does not reward you for being a good criminal.
I think the prosecution stated pretty strongly in their opening, you cannot reward somebody for being good at hiding a body. We don't have her body, but we can't reward somebody for being good at that.
I was also encouraged in my research to find that since 1843, 500 known no body cases as of July 2020, the article was from that date. That's how many have been prosecuted, and I'm sure the numbers have gone up since that date. During that time, there's been an 86% success rate for no body cases compared to a 70% conviction on all murder cases. The most important factors are DNA, such as blood, hair, fibers, fingerprints, cell records, surveillance records, and other tech evidence. According to the preliminary hearings and the different filings we've seen so far, we're expected to see several forms of evidence deemed, quote unquote, the most important, possibly even more important than human remains. At this point, 26 years later, Kristin would be reduced to bones. And just saying that shakes me up a little bit. I can't dwell on it too long. It's just too disturbing. But we do know to expect the DNA evidence, which was found on Paul's mattress in the dorm, which was a certain type of female DNA, it looks like. There was also fibers in the hole consistent with the clothing she was last seen wearing. There's also cell records involved. And there's other tech evidence as well, not to mention the body-sized hole where the blood soil sample was collected, as well as the fibers consistent with what she was last wearing. There's, of course, different witnesses. There's circumstantial evidence. There's the black eye. And most importantly, even as Chris said, the lies upon lies upon lies. There's all the evidence and proof of Paul's previous and continued sexual assault on other women as well.
Last word quickly, Jen. The blood, the supposed blood in that soil, 20 years. Is there anything there, do you think?
Well, there's enough there to tell that it's human. So a grave-shaped hole in the ground under your deck with human blood in it certainly is not nothing. So it's a great end to a story, I would say.
Absolutely. And for jurors, they're looking over at the table, seeing dad and boy, and it's at dad's house. Makes sense how he could have gotten away with it because he had the help. It wasn't just a college kid with a body. It's dad in his pickup truck coming to the dorm and helping him out. That's the allegation from the state. Thank you both, Jen.
I'd like to share with you some clips from an interview with a local attorney here in San Luis Obispo. His name is Funky Baloo, and it really clarifies some of the important court processes. He's been practicing for over 40 years and is highly regarded in our community. I always value what the experts divulge with all their knowledge. I did attend law paralegal classes years and years ago, and then I went the other route, married, kids, and all that, and chose a different career. But it definitely comes in handy having some basic knowledge and understanding of the law. It's actually saved me tons of money, actually, over the years, even with my minimal knowledge. But I only know a small fraction, of course, a teeny smidge compared to these long-time practicing attorneys. So it's always good to hear what they have to say.
I can't think of any jury trial where a jury does not receive an instruction on witness credibility. And I've just taken a small portion of what's called Cal Crim 226, and I'd just like to read it. It's just a short paragraph. The jury's instructed as follows, at least in part: do not automatically reject testimony because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes forget things or make mistakes about what they remember. Also, two people may witness the same event yet see or hear it different. So that's inconsistencies in and of itself may be important if the jury so concludes after considering all the facts and the instructions, part of which I've just read to you, the actual instruction the jury will get. I can promise you that. And lawyers don't usually promise things, but this I can promise you. The jury determines the importance and the weight to be given to inconsistencies, not the attorneys, not the judge, but the jury. They are the triers of the facts.
Remember in my previous video when I was mentioning how the defense is focusing on supposed inconsistencies of witnesses, witness recollection from 26 years ago? Ross, one of the witnesses, and Cheryl specifically I'm mentioning. And it sounds like the inconsistency regarding Ross was whether or not Paul's arm was around her or whether they were just very close.
So one of the witnesses that we just showed a picture of, Ross Ketchum, he just attended the party and he saw them together. And then his testimony had some inconsistencies as well. He talked about the fact that he thought that he saw Paul and Kristin together. He definitely saw them together drinking, but there was a bunch of discussion about whether or not he had his arm around her. And again, these were like inconsistencies being pointed out by the defense attorney. Consistency popped up about whether or not he remembered Paul having his arm around Kristin. The other thing that kind of popped up that made me question a little bit what goes through juries' minds, and obviously you don't know what goes through juries' minds, but you've done this a lot and you've presented evidence in front of a lot of juries, and these are things that you think about, no doubt, right? Is that when he was talking about her falling at one point in time, he referred to her falling off an area of the kitchen and falling off a washing machine. And that kind of became a point in the courtroom because obviously washing machines aren't necessarily in kitchens. And I have a feeling, or my perspective was that he was just really, really nervous about testifying. And maybe it was a stove or something. How much do nerves play into it? And how good are juries at sort of overlooking those types of problems?
Well, again, a good jury is a jury that finds the truth. A bad jury is a jury that does not find truth. Or cannot find the truth. Bias is akin to inconsistencies. I've only read you a small portion of Cal Crim 226. There's another portion of Cal Crim 226, a specific instruction that the jury will get, that talks about bias. And the instruction instructs the jury must consider bias and determine what weight, if any, to put on a witness's testimony. Again, if the bias is so strong that the jury feels that the testimony is tainted and is not credible, then the jury has the power to reject it. But just because a witness is biased doesn't mean that the witness is untruthful, right? From a single perspective. You got to look at all of the facts, and only a jury is qualified to give us what those facts ultimately mean, not the lawyers or the judges. So everyone is nervous when they come into the courtroom. Even with all the experience that I've had, there are times, even today, where I can be nervous in a courtroom. You're dealing with people's lives. You're making important decisions. You're impacting people. So you would expect people to be nervous, and you would expect them to be even more nervous when they don't have 43 years of experience behind them. To give them some sort of comfort level when they go into a courtroom. So will a jury see that? Of course a jury will see that, because the jury themselves are nervous. Most of them probably have never had the task of deciding the guilt or innocence of one of their peers. So they understand, trust me, juries and jurors understand nerves, and they understand nervousness. Again, just because a witness is nervous doesn't mean they're untruthful. The reverse of that, of course, is that sometimes you have a defendant who you're reluctant to put on the stand because you're so concerned of his nerves that the jury might misconstrue his nerves and his nervousness as consciousness of guilt.
Oh my gosh, what are the odds that they will testify in their own trials? Let me think about it. I'm going to say slim to none, like no chance in heck.
First, I'm kind of assuming, maybe, and maybe I shouldn't be assuming, that the family members of Kristin Smart testified first so they can sit in the courtroom. Like each of them, was obviously barred from the courtroom until they testified, but now all of the family members have testified and they are sitting in court.
I've had an experience with this when I was a witness in a vehicular manslaughter trial, where I had to sit back in this little tiny room and I couldn't hear anyone else's testimony. And after I was done, the prosecution told the judge that I could not sit in the courtroom to witness the rest of the proceedings because he might recall me. Not to make this video about me, but to show you what can happen in the quote-unquote justice system, is he actually tried to manipulate me, and he made me sit in that room for 5 days. And when I told him I was a single mommy and I needed to make money, because if I'm not at work, I don't make money, he screamed at me and told me he could keep me in there for weeks if he wanted to. I did complain to the district attorney, and it's a long story, but a lot goes on behind the scenes for sure.
If the witness is excused, after the witness completes his or her testimony, if the witness is excused by the court, then they're no longer a witness, and then they can sit in court. A trait that attorneys like to do is when the court invites the attorneys, do any of the attorneys have an objection to the witness being excused? One of the attorneys will pipe up and say, yes, I want the witness subject to recall.
Yeah, that's happened, honestly, with every single witness, minus the family.
Every single thing done in the court proceeding is strategic. It's also like a stage for the lawyers as they put on their best show to prove that what they're saying is what the jurors should believe. There's a reason of the order of who testifies when.
So in terms of the order, there's two theories here that apply. Testimony. So some lawyers feel that you want to present your most powerful evidence right in the beginning of the trial to hook the jury in to the testimony, to the witness, and to the strength of your case. Other juries believe you should build it up and until the end. In other words, recency, so the jury, when it goes into deliberations, will remember the more recent evidence and will place more weight on that than what they heard 3, 4, 5 months ago when the first witness was thought to be the all-powerful testimony that the attorneys felt was necessary to begin the case. I suspect, because of the length of this case, that both sides will focus on recency because the cases will take such a long time that you want to save your best for last.
It's interesting to hear the strategies for who testifies when, and we will definitely expect the best for last. We've already mentioned in the past that Susan Flores, Paul's mother, has tried to fight having to testify in the trial. It was recently released that she will be required to testify. However, the insight from this attorney makes me wonder what, if anything, she'll actually have to say. I still have the research and photos, etc. together for the episode I wanted to do on Susan Flores and her boyfriend Mike and their alleged involvement in helping at least hide Kristin's body. But to be honest, I'm scared. She's crazy, and I live in this town, and I just don't think it's worth it.
About Susan Flores testifying, and there's been a lot of questions about that, right? Because she's been sitting in the courtroom at times. She was sitting in there for opening statements. Witnesses are usually precluded from sitting in the courtroom before they testify. Can she testify, and is there a limit to who she is expected to testify against? Like, can she actually be asked questions about her son? Can she be asked questions about her husband? She still is married, even though they're not in a traditional relationship. She still is married to Ruben legally.
I don't know how much the court will allow probing into communication between Susan Flores and her legal husband, Ruben Flores, even though technically they've been living, as I understand it, living apart for many years. They're still technically married, and they're still entitled to the marital communication privilege. Prevents the law from penetrating those communications. I think what the other part of what you were inquiring was whether she'd be allowed to testify at all, given the fact that she's sitting in the courtroom.
Exactly. Or how the judge determines who can sit in the courtroom ahead of testifying and who can't.
Well, it's completely discretionary with the judge or the court. Most of the time, the court will not allow any witness to sit in a courtroom, regardless of the relationship. However, I've noticed in my experience that judges, especially in the more serious cases, like the case against Mr. Flores, when there's so much writing on it, the court will allow a family member to sit in the courtroom and be there as support for the defendant because of the strong family relationship, being a mother or a father or a sibling or whatever. But I can assure you, if Mrs. The defendant's mom, if her testimony was critical, if the court felt that the defendant's mom, her testimony was of such importance to the case, I don't care how close they are, mother and son, no judge would allow her to sit in the courtroom if her testimony is so important. I suspect it's not.
Wow, that was a little bit of a shocker to hear that Susan and Ruben are still legally married. Over the years, I've heard both. And more often than not, I heard that they were actually divorced. I wonder what is true. That was a lot of good information provided by that lawyer. Hopefully it gives us all insight into follow the case better and understand what's going on as the proceedings continue for months and months and months, October at least. The lawyer explained it in much greater detail, but basically testimony, when you look at the testimony and listen to it, you decide whether what is inconsistent is major or relevant or minor and not. It's pretty simple, common sense. Remember in my last video how I was trying to figure out how in the world Paul can afford his high-powered attorney? Well, it's interesting. A lot of the things I wondered about last week are being answered in my research this week. So this is what I found regarding Paul and how he's going to pay for his attorney.
Let's get to this idea of cost. Obviously the Floreses have hired their own attorneys. They're not being represented by a public defender. I'm assuming, and all of our viewers kind of want to know, what kind of numbers are we talking about? How much does it cost? And where is that money coming from? The average person doesn't have that kind of money to sort of cough up in terms of paying for defense lawyers.
My sense, based on everything that I know and my judgment, this is going to be in the neighborhood of $400 to $500K easy. My hourly rate is $500. I think Mrs. Sangers says that it's in that neighborhood. We're talking about traveling to Monterey County, which is several hundred miles from Mr. Sanger's base. He has a private investigator that is there. He's had another attorney work with him. These issues this case is extremely complex, covers 25 years of material, thousands and thousands of pages to review, multiple witnesses that have to be contacted and examined and on call. So yeah, this would cost at least a house.
So it's funny that you bring that up. Is that one of the ways that the cost can be covered? And I asked this question because I looked into that, and the house that was owned by Paul Flores was actually transferred into a trust, for instance, when he was right around the time of his arrest. And I might be reading into that. I just wanted to look and see if there was any connection there.
Fees can come in all shapes and sizes. God knows, I once took a rowboat with a couple of oars. I have taken a house one time. The key is to make sure the house is not encumbered.
Yeah.
As long as it's legal tender, I think a defense attorney will take almost anything that's clean.
So interesting. At least $500,000. The cost of a house. Paul's house put in trust. I wonder if that means that's part of the payment. What do you guys think? Makes sense to me. This is his home in San Pedro, California.
And likely we will never know, right? This is not something that has to be disclosed.
What has
like the cost or nobody has to disclose it, right? Whatever deal was made between those attorneys and the Flores family is their deal.
It's all confidential.
Yeah.
It's part of the attorney-client communication privilege.
Yeah. So and likely, we're gonna never find out.
Let me just add one thing.
Huh?
If the money or the in-kind money is provided by a third party, there's no communication between that third party and the attorney. The attorney's entire fiduciary relationship, confidentiality, is owed exclusively to the client. So when you say it won't be exposed, I'm not suggesting. Let's assume that the parents, and it's not that unusual for parents to help their children when they're in trouble. Let's assume that the parents are helping Mr. Flores. If they want to disclose it, there's nothing to prevent it.
I really hope that the information comes out eventually. The truth of the matter is the family is helping him because apparently they bought him the house in San Pedro originally, from all reporting that I've heard. That's, of course, if the assumptions of the interviewer, the attorney, and myself are indeed correct.
I think some of our viewers too want to know, like, whether some defense attorneys might take cases like this just for the kind of notoriety of it, or for additional, like, the ability to get additional clients. Does that ever factor in?
I think absolutely. I'm fortunate enough where I don't think I have to take a case for publicity, nor do I have to take a case just to make money. I'm not suggesting that's not significant. That's very significant. But if the client is a jerk, I'm grateful that at this point in my life, I can tell the client to go find someone else.
That expert opinion confirms what I was already considering regarding notoriety sometimes being part of the consideration of defending somebody in a case such as this. In my research, I'm realizing the same things that I wonder about are what others interested in the case are wondering about. I'm happy to find this insight, and I'll be happy to continue to share this with all of you. I have to admit, it kind of made me chuckle when that other attorney who's been practicing, I think it's for 43 years, talked about how he doesn't need to, nor does he, take cases for notoriety anymore. I don't know. Read between the lines on that one, I suppose. We will soon also hear testimony from some of Paul's sexual assault victims and other people describing his tendencies, his perverted ways, and the disgusting things he would do to women, especially when they were inebriated, which sounds very familiar. This speaks about the LA probe in Redondo Beach and other women who have been victims of Paul Flores.
Where again he came under the scrutiny of law enforcement. In LA's Redondo Beach, Flores was being investigated for rape and was a suspect in 2 more cases of sexual assault. In the Redondo Beach case, the LA Times reported that in 2007, a woman had gone out with friends and had some drinks. She told police that after drinks, she awoke in a stranger's bed, naked and wrapped in a blanket. She had no memory of meeting the man beside her or having sex with him. According to her medical exam, there was no obvious indication of force or assaultive behavior. In 2011, 4 years later, the DNA sample collected from the woman's body was identified as belonging to Paul Flores. Initially, the woman, referred to as Rhonda Doe, could not identify Paul from a lineup, but now prosecutors say she is certain that it was him after seeing a photo of his driveway. In the end, Los Angeles prosecutors did not charge Flores with rape. After decades of suspicion, Paul Flores was arrested last April for Smart's murder. And during a press conference announcing his arrest, San Luis Obispo County Sheriff Ian Parkinson told reporters that investigators had discovered something of value in renewed searches of the homes that linked Flores to Smart's death.
Detectives served search warrants at the home of Paul Flores, as well as his sister, mother, and father, all simultaneously. During the search warrant, detectives recovered evidence related to the murder of Kristin Smart.
Flores was charged with murder, while his father, Ruben Flores, was charged. While the charges of rape won't be considered by a jury, evidence of Paul's alleged sexual misconduct will. California law allows prosecutors to admit such evidence to show his predisposition to commit sexual assaults. 3 women, including the woman in the Redondo Beach case, are expected to testify Paul Flores drugged and raped them. Prosecutors hope to convince a jury that Paul attempted to do the same to Kristin Smart.
We are all looking forward to the hearing this Thursday, the week of August 1st, 2022, related to the Media Coalition motion, so we can actually start seeing some of this evidence, some of this testimony, and these other things that have been kept from us when in most trials you have access to these things. So Chanley Painter actually touches on a little bit of the details and what we can possibly expect the outcome, hopefully when it's successful, regarding the motion by the coalition to release more details and unseal the records.
We are expecting next week a hearing for a motion that was filed by a media coalition to unseal the record. This case has been under protective seal virtually from the beginning. So there's a very, very very little known about what's in the case file and what has been litigated back and forth. And a lot of the affidavits and information has been sealed. Opening statements are the most that we've heard about the evidence the prosecution has because of the protective order. So there is a motion by a media coalition that will be heard next Thursday.
Since we have no access to the courtroom, I'm always intrigued when there's some insight. And apparently Mr. Paul is extremely helpful in the courtroom.
The courtroom, they have separate juries being tried together. She talks a little bit about the interaction between father and son.
This is a photo of, what I watch when I'm sitting in the gallery when I was there inside the courtroom. Paul and Ruben are sitting side by side. They don't have their attorneys in between them. So that indicates to me that they're getting along, they're communicating, and they want to see each other, right? And they are sometimes shoulder to shoulder, touching, talking, passing notes, helping each other out. It's really unlike anything we've seen. A lot of times co-defendants on trial together, Michael, aren't looking at each other. They aren't talking to each other. But father and son are, and it's really interesting. Paul also really is kind of like his co-counsel. Paul Flores will work the technology for his attorney, pass items to his attorney when I'm in there. So it's just really an interesting dynamic.
Here's some of what we can expect next week in court. I'll be sure to do all my proper research, compile it, and get it to you guys as soon as I'm able.
Painter Chaley has been covering the case for us in California, and she has a preview of what we can expect next week.
Well, we can expect the prosecution's case to continue calling those key witnesses, those former students who were at that off-campus party where Kristin Smart was last seen, to talk about their observations of her, how she was acting, who she was with, and more importantly, what Paul Flores was doing at that party, and help walk her home. So that's where we expect to pick up on Monday, some of that key testimony.
Justice for Kristin.